Thank you so much, Fiona, and good afternoon, everyone. So, yes, welcome to today's session, Switch On to Wills, where I'm hoping to demystify the topic and look at some of the reasons why it's really so important to think about what will happen to both your money and possessions after you've gone. But before we chat through the agenda, just a few quick introductions. So I'm Amy Staines. I'm the Senior Financial Education Manager at Better with Money, and Better with Money is an independent provider of financial education. So we provide webinars like these really to try and help bring some of these money matters to life and hopefully as a result reduce some of the stress that can come with managing money. Also, just a couple of housekeeping points from my side. So, first of all, the session today is providing information only. So, I'm not going to be providing any sort of financial advice, but instead, I'm aiming to give you the tools and knowledge to make your own decisions about your finances, and in particular today, things like wills and powers of attorney. Also, because Better with Money is an independent provider of financial education, we're not connected to any of the companies or websites that I mention as we go through today, and we have no financial products to sell. So, where I do mention websites, organizations along the way, it's because we genuinely believe they offer really useful tools and information that you can take advantage of rather than because we receive any sort of financial incentive to do so. And just to reiterate, the session is being recorded, so you will be able to watch it back afterwards, and there will be time for questions at the end. So let's get started and take a look at our agenda. So over the next 20 minutes or so, we're going to look at, first of all, why a will is so important, and then the options you have for making one. We're going to cover the basics of inheritance tax and making gifts of money as well. We're going to briefly look at trusts and how they're used, and then we're going to finish off with powers of attorney and why they're important too. Before we start, I do just want to mention that there are differences between the rules in England and Wales, Scotland and Northern Ireland, particularly when it comes to wills and inheritance. So I will be looking to point those out along the way. And I also want to acknowledge that some of these topics can be quite difficult to think about, quite sensitive. After all, it's not nice to consider what might happen to us when we're not here, but it's a really important part of our longer term planning. And to be honest, it's not always about just longer term planning because some of these things can be needed in some cases sooner than we think. So, really important topics to think about. But let's start with wills. And I do wonder how many people on the call today have a will already. Because if you haven't, you're certainly not alone. There's some research on this by money.co.uk that suggests that 60% of adults in the UK haven't written a will. But actually, in England, Wales, and Northern Ireland, you can write one from age 18, and it's actually age 12 in Scotland. So let's first think about why you should consider having one. And first and foremost, it tells people two very important things. So, first of all, who you would like to have your money, property, and possessions after you die. This is known as your estate. Now, that word estate might conjure up the vision of a stately home in the country somewhere, but actually, your estate is quite simply the money and property that you leave behind. So that's the first thing. But secondly, your will also sets out who you would like to be in charge of organising that estate and following those instructions that you leave in your will. So it appoints the person called your executor. You can name more than one person as your executor if you want to, and you can choose whoever you want to be your executor. It should be someone you trust, someone who will follow through your wishes. Most people do choose close family members or perhaps friends. You can use solicitors, but that can be quite an expensive option. They do often charge quite a lot of money for that service. But whoever you choose, you should make sure those executors are willing to act for you, and they should also know where all your paperwork is. And another important point to consider is age as well. So be wary when you are choosing your executors of anyone who is perhaps a similar age to you or older, as practically they may not be around when their job of executor kicks in. So it's important to be mindful of that. And it is also worth saying that being an executor isn't always straightforward. There's quite a bit of form filling in that they will have to do. It can be quite time consuming, quite complex in some cases. And even those who are financially savvy may ask a solicitor to help complete the HMRC probate forms. So do think carefully about who you're choosing. you ideally would have someone who is relatively financially savvy, organized, and has that time. You could ask a solicitor, as I say, but that can be expensive. So just think about the cost, make sure you're choosing the right people around you. But aside from your executors, if we just think about what else you can include within your will, well, if you have children under 18, then you may want to set out who will be their guardians if you weren't around to look after them. And those guardians can be different people to the executors. And you can also use your will to tell people about any other wishes you have, like instructions for your funeral, charitable donations, what should happen to pets after you've gone as well. So there are loads of reasons why you should think about this. And there are lots of things you can include within the document. But let's just think for a second about what happens if you die without a will. Well, simply in that case, you're deemed to have died intestate, and that means that an application needs to be made to the court before the legal administration of your estate can begin. Now, that application would usually be done by the closest family members to you. So it might be a spouse, it might be a child, and the application is to request authority to then deal with that estate. They'll need your death certificate to be able to make that application. They'll also need details of any money and property being left behind. And this process can take some time. How long it takes will depend on the situation. So if you're married and the application is made by a spouse or civil partner, that process is more likely to be straightforward. Whereas if you had, say, only distant relatives alive, and supporting with that, it could be a more drawn out process. So it is a lot simpler for the family you're leaving behind if you have written a will, nominating that person that you wish to be the executor, as that cuts that step out. And this is particularly important if your situation is more complicated. So let's say you're not married to the person you're living with, or you're not in a civil partnership. If you're divorced, if you say had stepchildren, or perhaps if you had assets abroad or other property. Because if you don't have a will, or if that will is not accepted for any reason, and we'll come on to talk about invalid wills, but in those cases, the government will then dictate what happens to your money and your property, and that might not be in line with what you want. So this is not only about protecting your family and your heirs financially, it's about ensuring your money and possessions go to the people you want them to go to. And all of this can help to avoid family stress of dealing with that estate at what's often already a very difficult time. So wills are important. Let's just look in a little bit more detail about what happens to your estate if you don't make a will. So this is where the rules are slightly different in the different countries within the UK. But if we look at England and Wales first, so if you don't leave a will in England and Wales, when you die, your estate will be distributed according to the rules of intestacy. And you can find the full details of those on the government website at the address I've linked on the slides here. And ultimately, these rules can get quite complicated, but at a high level, your spouse or civil partner would receive any assets first, followed by children, and then parents. And again, the main point that I just want to reiterate here is that if you're living with a partner, but you're not married, or you're not in a civil partnership, your partner would not automatically be entitled to anything if you passed away without a will. And if you had no living relatives, then the state would get the lot. But if we just think about Northern Ireland, things are a little bit different in that your estate is distributed in line with the Administration of Estates Act 1955. The thresholds are different than in England, and your spouse or partner would have to outlive you by 28 days to inherit anything. After that, if you have no children, then the estate would follow a similar line to England in that it would go to your parents, siblings, aunts, and uncles. And then in Scotland, things are different again. The first thing that happens is that your debts and liabilities would be paid. After that, your spouse or civil partner would be entitled to what are known as prior rights. And then if any assets are left in your estate after that, they'd be distributed to your spouse or civil partner and children under the legal rights rules. And then after that, as you can see on the slide, the remainder of the estate would be distributed in accordance with the Succession Scotland Act. So These rules can get quite complicated and they are very prescriptive under these different legislations. And this can make it all very time consuming. So, again, to avoid having money left to people that perhaps you don't want it to go to, or leaving your family to guess who you want to have your possessions, this is why it's really important to leave a will. So, let's now look at how you can do that. And theoretically, anyone can write a will. And there are various routes that you could use. So in that box on the right hand side of the slide here, so solicitor, will writing service, charity scheme, or a DIY will. So let's just run through each of those, starting first of all with a solicitor. So the key thing here is that a solicitor should be regulated by the Solicitors Regulation Authority or the Law Society of Northern Ireland. And most solicitors who offer this service will be specifically trained in making wills. And this is important because wills are legal documents and they can be invalidated by even really small mistakes. So the case for using a solicitor is that they generally know their stuff and will hopefully therefore produce a will that's really watertight. And they will also witness that will as well, which means it's less likely to be contested by the probate office when you pass away. And we will you will hear that a few times during the session, the probate office. So that's the part of the government that your estate is reported to by your executors when you pass away. So an important part of the process. But solicitors can be a good route to take, particularly where you have perhaps more complex financial or family situations. And in terms of cost, well, simple wills can start at around £200 to £300. They may also store your will at no additional cost. Where situations are more complex, particularly relating to family and assets, that cost could increase. So around £1,000 for a more complex will. But again, it will depend on the particular solicitor that you use. But the next option is a will writing service. So that can be a good low cost alternative to using a solicitor. Prices usually start under £100. They might be done online, they might be done in person. And this service is generally most suited to those with straightforward circumstances. So let's say you're leaving everything to your immediate family, you don't have any complex assets, you don't have any assets overseas, you don't have a business, for example. But saying that, there can be a vast difference between will writers. So you can come across one-man bands, perhaps with no qualifications. You might have other will writers who are based in professional firms. They might be regulated by the Society of Will Writers and adhere to codes of conduct from the likes of trading standards. So do think about within that will writing service sphere who you're using, and it can be really helpful to check if they have professional indemnity insurance. Hopefully, they'd have insurance of around 2 million, at least 2 million, just in case things do go wrong. But again, they may offer to store your will as well as part of that service. Now, the next one here is a charity scheme because many charities do offer free will writing services by solicitors. So you can literally look on charities' websites, see if they offer the service. You usually apply via the website, they'll send you a pack, and then they will tell you which solicitors you can approach in your local area. And this is really great, particularly if you're looking to put a basic will in place. The service is usually free, although the charities do hope that you will make a donation to the charity within your will. And I have listed a few charities on the next slide. And I do just want to add that I actually did sort my own will through a charity scheme earlier this year, and it was really, really easy to do. So I applied online, I approached a local solicitor. I literally had a 30-minute meeting in person. I went back to sign the will a few weeks later, and then it was all done. So super straightforward. I did decide to leave a donation to the charity, but it didn't cost anything to have that will written. So if you are thinking that, this is a really lengthy process, a complex process, I can assure you that it doesn't have to be, particularly where your financial circumstances are fairly straightforward. But if we just think about the last one, so DIY wills, these are generally only used for very, very simple situations. So this is where you access a will template. You might find it online. You might get it from a stationery store, the post office. They might cost only around £10. But the key thing here is that the suppliers of these templates won't take any responsibility if that template is wrong or if that will turns out to be invalid. So this is the cheapest route, but there is that risk of not having a valid will. And there are various criteria that are needed to make that will legally valid. So you can see those on the slide here. It needs to be in writing. It needs to be made by a person of sound mind. They should be over a certain age, and the will should be properly witnessed as well. If the will doesn't comply with these requirements, it may be invalid. And simply, if it's invalid, you will be deemed to have died intestate, so basically without a will. So if you're going to go through the process, do make sure you're doing it right and the will is watertight. And just thinking about storing a will, well, you can keep it at home, but there are kind of risks that do come with that. If something happened to the will, if it wasn't accessible, it might be locked in a safe that the executors can't access. So there are other options there. So solicitors or will writers, as I've said, might store that for you. There is also the probate service. You can store it there for a flat fee, and then it can be retrieved at a later date. So do consider this as part of your planning. And there are some really great websites that can help as well. So first of all, you've got those charity schemes there, but they're just a few. So if there's a particular charity you'd like to look at, just have a look on their website and see if they do support with a will. I then want to call out Free Wills Month. So it is now October. Free Wills Month runs in both March and October. So we're there. And if you're thinking about writing your will, this month might be the month to do it. But essentially, Free Wills Month allows those aged 55 or over to get a solicitor drafted will for free. It may depend on the area you live in as to which month applies to you. So again, take a look at that Free Wills Month website. Will Aid is very similar, but that tends to run in November and it's generally open to anyone of any age. They do suggest a donation for a will of £100. So again, have a look online, see if that's something that you can make use of. And I've also put a couple of websites there where you can find a solicitor to write wills if you need it. So loads of support out there to help you get a will written. But let's now move on to inheritance tax, which is a key consideration when thinking about the assets that you leave behind. So if we just think about what inheritance tax is, first of all, it's a tax that's payable on an estate after someone passes away, if the value of that estate is above the allowance. So that allowance, as you can see here, is currently £325,000 per individual. That does apply across England and Wales, Northern Ireland and Scotland. So above that threshold, that's when inheritance tax becomes payable at a rate of 40% over the allowance. So on that excess over that threshold, that 40% does reduce to 36% if more than 10% of the estate is left to charity. But essentially, no inheritance tax is payable if that estate is below that 325,000 threshold, or if you leave everything to a civil partner or spouse, a charity or community amateur sports club. It's also worth knowing that there's an additional tax allowance, so that's known as the residence nil rate band. That's available where a family home is passed on death to direct descendants, so children or grandchildren. So if someone leaves their home to their spouse or kids, £175,000 is added to that inheritance tax allowance, making 500,000 free from inheritance tax. If that property is left to someone else, so not a direct descendant, that allowance won't apply. And the other criteria is that your total estate must be worth less than £2 million as well. But if the value of your estate is over these thresholds, then any inheritance tax would become payable, and that would usually be paid before any assets are distributed to your beneficiaries. Now, I also want to mention that when executors are filling out the probate forms on your death, they will be asked if you've made any gifts in the last 7 years. And that's because any gifts within 7 years are also added to the value of your estate to help calculate this inheritance tax liability. And that's basically so you can't avoid inheritance tax by simply gifting away all of your money just before you pass away. Saying that, there are some gifts that you can make which are free from inheritance tax, irrespective of how much your estate is worth. and irrespective of when those gifts were made. So this is what you can see here. So just to run through these quickly, gifts between spouses or civil partners, they are exempt. Gifts under £250 per individual, so for things like birthdays or other festivities. Wedding gifts up to certain thresholds, depending on who you're gifting them to. Regular gifts out of income is quite an interesting one. So the key with these is that they shouldn't impact the normal lifestyle of the person giving that gift. So an example of this, one of my colleagues' dads is giving her daughter, so his granddaughter, a small allowance every month while she's at university. So that's coming out of his pension. That wouldn't be counted for inheritance tax because it's coming out of income, it's not coming out of savings, and it's not impacting his own lifestyle in any way. But lifetime gifts up to £3,000 a year as well. So a person can give up to £3,000 away every year during their tax lifetime. Sorry, every tax year during their lifetime. It might be a single gift, it might be several gifts adding up to that amount. And then also gifts to charities, universities, museums, political parties are also exempt. But inheritance tax can get quite tricky. So if you need support with that, you might want to speak to a financial advisor, and unbiased.co.uk is a good place to start if you are looking for that type of advice. So that's where you can go to find a financial advisor. But I just want to talk a little bit about trusts. So, inheritance tax does generate billions of pounds for the UK government every year. So, one of the things that people can look at when estate planning is how best to pass on those assets to future generations in a tax efficient manner. And this can involve using trusts. So, trusts are one of the older forms of English law. They started life in medieval England around the 12th century. But today, trusts are used either to pass assets during an individual's lifetime or to help determine what happens to someone's estate in the event of their death. And these types of arrangements can be particularly useful where perhaps large sums of money are involved, where family relationships are complicated. And above all, this is about placing control over who can receive assets or property and also when they become eligible to receive them. So you can see on the slide here, there are two main types of trusts, lifetime trusts and will trusts. Will trusts are only created once you pass away. So you set up the conditions of that trust in your will, it activates upon your death. And then there are lifetime trusts as well. So these are set up straight away whilst you're still alive. They may face some tax charges. So there might be an immediate 20% tax charge when you're setting up the trust. There may be further tax bills periodically throughout, and other taxes associated as well, things like capital gains tax, depending on how that money is invested and managed. So these can be quite complicated again. It's likely that you would need to take professional advice if you are looking to set up a trust. And it's also important for trustees to understand what they're doing as well. They should understand roles and responsibilities. So professional trustees are often used if you are thinking about this. So they can be a good idea. They can give you greater control in determining where your assets will go, but they can be quite an administrative burden to set up. There is still potentially inheritance tax to pay. So it's worth speaking to the right people, using professionals, and in the right circumstances, they can be an efficient and effective way to plan ahead. So looking at how you can set aside funds for future generations and hopefully, reduce some of that inheritance tax burden as well. But conscious of leaving a few minutes for questions, so I just want to finish off by covering power of attorney. So equally as important as wills, these are legal documents that allow you to appoint people to make decisions on your behalf if you're still alive, but if you don't have the mental capacity to make those decisions yourself. And there are various ways that you might lose mental capacity. It might be a dementia or Alzheimer's situation, or you might have a stroke, or perhaps you're involved in an accident. So appreciate not nice things to think about, but it's really important to have these conversations. And these conversations aren't just for elderly people. Some people assume that, let's say you became ill, or if you were involved in an accident, that your next of kin would simply be able to make decisions for you. But in reality, our next of kin have no legal rights unless they're a parent making decisions for someone who's under the age of 18. So if you don't have a power of attorney, Your family can't legally access your bank account. If you had a joint account that needed two signatures, your partner might not be able to access money. Your investments or benefits might be frozen if you can't sign the necessary paperwork. So, this is where a power of attorney comes in. It's about giving that legal authority to someone else to let them act for you and make decisions on your behalf. Again, there are differences in rules for England and Wales, Scotland and Northern Ireland. So, in England and Wales, for example, you can apply for lasting powers of attorney to cover health and welfare decisions, but also finance and property decisions. So, there are two separate documents, two different types of lasting power of attorney. In Northern Ireland, you'd make an enduring power of attorney, but you can only do one for finance and property. So there's no health and welfare power of attorney in Northern Ireland. And then in Scotland, you can make a continuing power of attorney to appoint someone to look after your property and financial affairs, and then a welfare power of attorney for those health and welfare decisions. So just to finish up here, without that document in place, there can be substantial costs involved. You'd have to employ a solicitor to apply for you to make decisions on someone else's behalf. That process can take some time to sort out. So, to avoid that, get this power of attorney sorted. And the key is remembering that you can't set these up once you've lost mental capacity. So, the key call to action is please act now to really help avoid issues and stress later on. But that does then bring us to the end of the session. But I just wanted to highlight, do remember you have access to support via the IC Benevolent Fund and the IMechE support network. So I've included contact details on the slide here, so you can go there to find out more. But I will now hand back to Fiona and we'll take some questions.
Fab, thank you, Amy. We had a question come in when you were on the inheritance tax slide, asking, does a state include life insurance payouts and pension payouts?
Really good question. So currently pensions aren't included, but following the autumn budget of last year, they're talking about bringing pensions into the estate for inheritance tax purposes. So that is something that will most probably come into play from April 2027 as things stand. But it's a bit of a watch this space scenario. Exactly how that will work, we're still not quite sure about. And there has actually been talk in the news very recently around life cover. So that's another area to look at. The rules are being looked at as we speak, essentially. So it is a changeable area. So a really good question. I can't give a definite answer right now in terms of what that will look like moving forward, but it is very much under review on both of those points, pensions and life cover. If we think about life cover in particular, particularly when you get that through work, through your employment, those sums can be significant and actually could potentially tip people into that inheritance tax bucket if their life cover means their assets are more than that 325,000. So yeah, it's a changeable area. As I say, with pensions specifically right now, no, but it looks like that will be happening moving forward.
Fab, thank you. We just had another question in. The free wills that you can get, they're assuming that they don't include lasting power of attorneys.
No, usually the free will schemes are just a basic will, but it's worth having a conversation with the particular solicitor that you use. So, in my own experience recently, the solicitor did bring up as I was doing my will that it would be worthwhile having a look at a power of attorney as well. So, yeah, they can usually help with both, but it would not usually be included within that kind of free wills fee. There would probably be a fee on top of that.